Hi, this is Mark Wahlstrom. Welcome to another edition of Speaking of Justice, a featured broadcast here on the Legal Broadcast Network. Well, today I want to talk about something that's going on in the structured settlement profession, which is near and dear to my heart because I've been in that profession for over 30 years. And it really ties into an issue in the news and a big featured story that the Washington Post broke earlier this year on the question of how structured settlement companies are approaching people who already have structured settlements. Now, there's a lot of confusion about this, and that's one of the things I want to really talk about today in this commentary is the issue of what is a structured settlement company. The whole issue the Washington Post is looking at were the lead paint cases that came to light due to the Freddie Gray issue in Baltimore. As we all know, Freddie Gray was a huge event this year. It was a tragic death. It brought about tremendous anxiety in the community, ongoing investigations, and even just this week, trials of some of the first police officers that were involved in that are beginning. But what also came to light, what the Washington Post reported on earlier this year through Terrence McCoy's series of articles, was the issue of structured settlement purchasing firms approaching structured settlement victims and offering to buy out their structured settlement payments. Now, this used to be known commonly as factoring, and as this article brought to light is that Freddie Gray was a lead paint victim, and Baltimore had an enormous, inordinate number of lead paint cases, over 4,000 from my understanding and research over a period of time, of children who ingested lead paint and filed claims against landlords, building owners, property owners who did not remediate or clean up those properties. And as a result, many of these children had severe and ongoing cognitive, learning, emotional disabilities that were compensated through these lead paint settlements with primarily property and casualty companies that own these buildings. Now, what is interesting about this case and what has occurred as a result of this series of articles on Washington Post is a whole new series of regulations were approved by the Maryland Appeals Court and kind of their judicial oversight process in the last week. And the things that they zeroed in on were, number one, the issue of independent financial advisors. Under the Maryland statute passed in 2000 that many states have, which is the Structured Settlement Protection Act, which is kind of standard language and format for each state. I think 49 states or 48 states have passed it at this point in time. But each one has a requirement that an independent financial advisor file a report with a court. Additionally, you had a lot of people, there was no requirement for the independent financial advisor to show up in court. And what came to light was what appears to be the rubber stamping of these deals where you're supposed to have an advisor go in, check the suitability of the arrangement, interview the client, and see whether or not the sale of their benefit stream at a discount is in their best interest. Well, what came to light in these cases is we saw or apparently what came up is that the same firms were doing work with the same advisors, and they didn't appear in court, but according to the law, they did what the law required. So my issue, and this is really kind of where the commentary on this starts by ending that preamble, is what we continue to hear and witness and see popping up over and over again is the issue of structured settlement companies. And as somebody who's worked exclusively for plaintiff attorneys and has worked on the primary side of putting structured settlements in place for injury victims, what I have found most troubling about this case is this emphasis on the fact that many of these people, in the words of the court, had mental or cognitive impairment. And, but yet, at the time of the settlement, many of them were children, in many cases. Some of them were adults. And again, you'd have to go through all of the cases and sort them out. But when you have blocks of cases, 100, 200, 300, 400 people selling their benefit streams, and the allegation is that when these people sold these benefit streams that they were not competent or were not sufficiently advised or were not aware of what they were doing. It also raises, to me, a troubling issue for the primary market, which I work in, which is putting these in place, working with trial lawyers, devising plans and settlement plans for people to take care of people over a long period of time, is what was the suitability study done at the time they were put in place? Now, I'm not in any way defending people who go in and prey upon people who are disabled or uninformed or selling them deals that they were not aware of. Again, I will let the courts, and to me, I think it's a court issue in Maryland. The courts had a process in place. To my knowledge, the companies followed that process, and what fell down was the enforcement of that process in the courts. And if they want to adjust that process and make changes in it, fine, that is a state issue, and that's something that they have to address. What I'm concerned about in my instance is, how did so many of these end up being sold and factored if in fact they were put in place appropriately? Now, again, I'm not casting stones at the trial lawyers, because the trial lawyer's job is to get the best possible gross aggregate settlement for these clients. And I think in most cases we could agree that these are fine lawyers, and these are people who knew their specialty and work in this area. And I have no doubt that they got every dollar that they could for their clients. But the question really becomes, were structured settlements suitable for these people? And this whole issue of, I'm looking at the structured settlement profession that I work in, which is the primary market, or the people who put these in place. And there seems to be a great deal of glee that somehow that they have, brought to light abuses which have aggravated and disturbed our industry for quite some time, about how people are solicited, how these are sold, that people are cashing in their benefits inappropriately. And we're now going to be looking at court supervision and court hearings that are more strictly enforced, that require independent advisors to show up and be in court to discuss conflict of interests. But the key issue that I'm looking at is if the independent advisor has to opine on the mental or cognitive impairment of the individual. Well, most independent professional advisors are in no way capable of making that decision. If the person is not adjudicated incompetent, we are looking at people who we have to guess are not impaired, but are legal adults who can make their own decisions. And I think that's the crack that these cases fell into, is that if these people were truly impaired, my question has been, and I've posed this to many people in my profession, if these people are as impaired as it is being alleged that they are, why were these not guardianships, and why were they not put into trust, and why were not guardian ad litems appointed at the time of settlement? And were structured settlements truly the appropriate vehicle for them? And what analysis was done? What suitability analysis was done at the time of settlement? Now, when you're settling a mass amount of claims on a mass amount of cases, it's very easy to slip into a process because we've seen it happen over the years, where it just becomes assumed that the structure is the best proposal. So my concern and my little issue of commentary here is, I think the primary structured settlement market, I think we can all agree that the factoring and the purchasing of existing structures needs continued to enhanced regulation and oversight. If these truly were being rubber stamped and these were being processed through and people were being taken advantage of, that is incumbent upon the courts in those particular states to address. And in this particular case, they've addressed it and it's been exposed. And I don't think it's going to impair people's ability to get structures. It may slow it down. It may make it a little bit more administratively cumbersome. It may make it more expensive. But the fact is that the procedures are in place, and if they're enforced, people can make an informed decision about their ability to get liquidity on their structure. But the point, again, that I want to make is by driving home this issue of suitability and the need for an independent professional advisor and judging the mental and cognitive impairment of plaintiffs, if we're going to insist upon that and require that for the sale of their structured settlement benefits, I'm concerned that we're going to begin to see a backlash from the factoring and the secondary market industry, that same standard is going to be applied on the front end when these are put together. As it stands right now, the structured settlement profession, when we put these in place, are one of the few financial professionals that do not have to do a suitability assessment on the sale of an annuity product. Now, it's an interesting exclusion, and I think there's a lot of reasons why that exclusion exists, and we can get into those at another time. But again, I want people to be cautious and reasonable when they talk about these changing standards and not just look at this as an opportunity to beat up factoring or secondary market companies that purchase annuities. We need to look at this in a holistic standpoint and make sure that our house is in order on the front end of these sales. Begin to look at this as a settlement planning decision, and if we have cases where we suspect or feel that people might be cognitively impaired, who may not understand the structure that they purchased, that we get suitability studies done on the front end, that guardians be appointed, or that attorneys be aware that this is a planning issue that needs to be resolved. Now, I know this isn't going to be popular with a lot of my friends in the structured settlement profession, but I think it'll be very popular with a lot of our friends in the trial lawyers area, because what they want, what trial lawyers want and what they're looking for, in my experience over the years, is somebody who comes in and does a comprehensive review and plan of what their client needs and makes the best effort possible to ensure that whatever plan is put in place, whether it's cash, whether it's a structured settlement, whether it's a Medicare set-aside account, whether it's putting their money in trust and having it managed for somebody over a period of time, whatever that plan is that it's being done in an objective and honest way by people who are not just there to sell a particular product or a particular solution, but really take a look at the needs of these people so that when these people aren't as vulnerable to the sale of their structures down the road because they've been put in place. You know, in my 30 years, I've probably had 3 clients in that period of time ever go and sell their structures. And if I had a case where I had 150, 200, 300 of my clients that went and sold their benefits, I would do some serious soul searching on my end as to whether or not those programs were put in place appropriately and we had planned their needs. So something for our profession to think about, something for people to review. We don't want to throw the baby out with the bathwater. Structured settlements are a valuable, valuable tool, and I think they were put in place with the best of intentions, but we have to be very careful about this whole issue of cognitive and mental impairment and suitability, because if we're going to require it on the back end, it's not going to be very long before it's required on the front end. So best practices, let's start doing it as if we have that standard already. Let's take care of our clients as most of us do, and let's try to enhance and elevate the professionalism of our little niche here that works with tragically injured people who need our help and need objective advice when they talk to us. Thanks. Appreciate your time. This has been a special edition and commentary on the Speaking of Justice. I'm Mark Wahlstrom. I'll talk to you again soon.